Yes, good morning, everyone. As we prepare to start, I want to welcome you to this training for today. I request that whoever is logging in, kindly rename and make sure you have your full names there and the sector. We're expecting people from the accountants sector and also the advocate sector. So you can just indicate your name and then a dash and then the sector you're from or the profession. Sorry, the right word is profession, an accountant or advocate. Thank you.
All right, good morning, everyone. You're all welcome. Thank you for making time to attend this training. My name is Fiona Navagala, Senior Training and Outreach Officer at the Financial Intelligence Authority. And the program will run as follows. We shall have opening remarks from the Manager, Compliance and Inspection on behalf of the Executive Director of the Financial Intelligence Authority. So allow me to take this time to call on Mr. Ngobi to take the floor.
Yeah, good morning, everyone. I hope I'm audible.
Yes, sir.
Good, great. I'm David Ngobi Ruigo. I'm Manager, Compliance and Inspections at the Financial Intelligence Authority. I'm making these remarks on behalf of the Executive Director, Mr. Sidi Nasubo, who is unable to make it to give the opening remarks as they are engaged in they have some commitments, but is with you. On behalf of the Financial Intelligence Authority, let me welcome all of you for this training. We are elated that the number has increased. I can see it is already at 357 and it's still growing. So we are happy that you have given it your time. The president of the Uganda Law Society, the secretary, Institute of Certified Public Accountants, all the advocates, and all the accountants, I welcome you to this very important training for the implementation of financial sanctions for the non-designated financial businesses and professions, which we shall be referring to as DNFBPs. I have slides which I will go ahead to share as part of the opening remarks, so that at the end of it we shall share them. As you are aware, of course, Uganda was placed on the gray list, and this has put us on our tenterhooks to have most of these taken up. But you as accountable persons, we urge you to take the trainings we are giving you seriously. So my remarks are based on, I don't know, my slide appears to be going off, but some technical hitches, but we shall continue. I will go ahead and share the opening remarks. So apologies for that delay, but in brief, I want to share that the anti-money laundering, combating financing of terrorism, and countering proliferation financing, AMLCFT framework is premised on global standards established by the Financial Task Force. The anti-money launderings, I always refer to those terms, they are abbreviated Global standards prescribe a framework for prevention, detection, investigation, prosecution, penalization, confiscation, and international cooperation. So the Financial Action Task Force is an intergovernmental body established by the group of 7 countries in 1989. Under the FATF, all member countries have an obligation to ensure that their financial systems and designated 9 financial businesses are protected against money laundering, terrorist financing, proliferation financing, and other crimes. So the Financial Task Force presently has 39 members, and in Africa, for your information, it's only South Africa, which is a member of the Financial Action Task Force. So it operates through the FATF-style regional bodies, which are called FRBs. These regional bodies adopt and monitor the implementation of AML safety standards. And in Uganda is a member of the Eastern and Southern African Anti-Money Laundering Group, which now composes of 20 countries in the Eastern and Southern Africa. So the FATF enforces compliance to global standards through the International Cooperation Review Group. The ICRG is composed of a team of experts mandated to analyze high-risk jurisdictions and recommend specific actions to address money laundering, terrorism, financial risks emanating from them. So the global framework has an established sanctions framework. FATF may place a non-compliant jurisdiction under increased monitoring, also known as the gray list. Of course, Uganda is now on the gray list. In February, we had 2 other additional countries in Africa. We had Nigeria and South Africa. Of course, even our regular destination, United Arab Emirates, is also now on the gray list. So jurisdictions may also be subjected to a call for action that is blacklisted if FATF deems them to be non-cooperative in the global fight against money laundering and terrorism financing. And in this regard, there are only 2 countries on the blacklist, that is North Korea and Iran. So the situation analysis. So as you realize that in order to detect any deficiencies and the strategic deficiencies, FATF uses a peer group of experts from sometimes from our region, and they carry out what is called a mutual evaluation, which is carried out every 10 years. Uganda, of course, first underwent the mutual evaluation in 2005, and then we underwent one in 2015, 2016 by the East and Southern African Anti-Money Laundering Group. Uganda scored low in all the 11 immediate outcomes, and as a result was placed under a 1-year observation period that ended in 2019. The post-observation period report conducted in December 2019 by the International Cooperation Review Group concluded that Uganda had not made tangible and positive progress towards increasing effectiveness of AML safety systems. So in March 2020, following a decision of the FATF plenary, Uganda was placed on the list of jurisdictions under increased monitoring. That was the greatest. Unfortunately, of course, government made commitments, political commitment to address the deficiencies. Unfortunately, there was the advent of COVID-19, and we had challenges in implementing the timelines, and that's why we are still on the gray list. So what does the impact of the gray list? Being placed on the FATF gray list implies that every FATF member country is required to exercise caution and take appropriate steps against financial transactions originating from or distant countries on this list. International financial institutions may apply enhanced due diligence measures, leading to unnecessary delays and increased cost of doing business. So when you are placed on the FATF gray list, naturally, the European Union will put you on the third world, on the third world, on the high risk jurisdiction. So, and the others are observers, IMF and the World Bank. So it means it is quite a big task for us. So when Uganda was placed on the grey list in February 2020, the National AML Safety Task Force, which is chaired by the Ministry of Finance, accordingly developed a plan to address the strategic deficiencies identified in the 40th Action Plan. As at March 2023, 18 out of the 22 Action Plan items have been addressed. Of course, when you are placed on the grey list, you report every 4 months. You have to, every 4 months, you have to report progress, and until they see whether you are addressing the action items. So 4 action items are outstanding, of which progress has been registered on them, which have been ranked as partly addressed. These outstanding action items will be discussed in the next reporting cycle of FATF in June 2023. But briefly, let me delve into the issues that Uganda had to address. One of them was to adopt an AML safety strategy, which we have done, and then seek international cooperation with the country's risk profile, develop and implement risk-based supervision of financial institutions and designated non-financial business and professions, ensure that competent authorities have a timely access to accurate, basic and beneficial ownership information for legal entities. And that's where you get why the Companies Act had to be amended to provide for beneficial ownership and many others. So it is a mouthful to implement it. And then demonstrate that law enforcement agencies and judicial authorities apply the money laundering offense consistently with the identified risk, to establish and implement policies and procedures for identifying, tracing, seizing, and confiscating proceeds and instrumentalities of crime. Then address the technical deficiencies in the legal framework to implement proliferation financing related to targeted financial sanctions. And that's the one we are now we are handling, because we had to amend the law to include proliferation financing. And according to the International Committee Review Group, we are supposed to carry out training of the related parties. And then lastly, to implement a risk-based approach for supervision of its NPO sector to prevent terrorism financing abuse. This has also been largely addressed. So the status of implementation, we have done many, but those which are relevant to you, one was according one of them was to complete the money laundering and terrorist financing risk assessment of legal persons and arrangements. So this one, the risk assessment was carried out with the assistance of Uganda Registration Services Bureau, and it was adopted by the Uganda AML Safety Task Force. So the risk assessment provides a broader assessment of the money laundering and terrorist financing risks related to legal persons and legal arrangements, and share it. And then to share the results of the risk assessment for legal persons and arrangements with private sectors. So this report has been made publicly available on our website and social media platforms. It was also disseminated to all stakeholders. So another outstanding item was provide guidance to financial institutions and designated non-financial business and professions on proper implementation of MLCFT obligations, especially in respect to customer, to MLTF risk assessment, customer due diligence, CDD, and targeted financial sanctions. This has also been largely done because as of now, the Bank of Uganda has issued guidance notes on these 3 areas: risk assessment, CDD, to the supervised financial institutions. So, and this is the one of them which we are handling. And then to ensure risk-based monitoring procedures and carry out on-site and off-site inspections. So then another one was take remedial actions and apply proportionate and dissuasive sanctions for non-compliance. In this regard, the Anti-Money Laundering Act 22 was amended to provide for administrative sanctions, the sanctions regime, and the current and amendments have been made also to the anti-terrorism regulations. The anti-money laundering regulations 2023 have since been issued. So this is one of them, that competent also should increase awareness on proliferation financing related target finance sanctions by providing written guidance to oblige the entities on the implementation of targeted 9 functions that are related to proliferation financing. So Ministry of Internal Affairs should increase awareness on proliferation financing related targeted finance sanctions by providing written guidance to oblige the entities on the implementation of TFC. This has been done by the anti-terrorism regulations have been amended, and also it is worth noting that the FIA, Financial Intelligence Authority, has given guidance on the implementation of this action item. And this is one of the training to which you have been invited today. Yesterday, we had the training of the of 4 sectors: the real estate sector, the NGOs, the dealers in precious stones, and lastly for the real estate sector. So government continues to address the action plan agreed with FATF. There is hope that the country will exit the grey list by end of this October 2023. But prior to that, we shall have an on-site visit from the International Committee Review Group. So amendments have been made to the laws which you identify to be deficient, and subsequently, His Excellency the President assented to some of them. These include the Anti-Money Laundering Act, the Anti-Terrorism Amendment Act, Companies Act, Partnership Act, Trustees Corporation Act, and Insolvency Act and attendant regulations. And there was also the Cooperative Societies Act. So all these were made in August-September period. Of course, there was a flurry of activity in Parliament, and they were passed within a space of 1 week, notwithstanding. So high-level delegations to financial, to FATF ICRG face-to-face meetings and the Samla Council of Ministers have been made in September. That was in Livingstone in Zambia, January in Morocco, and May in 2023, and included high-powered delegations led by either the Minister of Justice and Constitutional Affairs, Honorable Attorney General, Honorable Minister of Finance for Planning and Economic Development, or the one for general duties, and always the Minister of State for Internal Affairs. And naturally, they have gone with the technical staff. So the country has got a positive review due to these renewed efforts, which is reflected in the latest assessment. Before I conclude then, I would want just to take this opportunity to urge you that this is a matter for our country. Let us be patriotic and take this training seriously, because whatever we undertake now is shared with the ICRG, including the recording and everything and all of attendance. So your participation is a great boost to this. But before I close, I want to urge our colleagues, especially the advocates, that you as accountable persons, please, we urge you to register with the Financial Intelligence Authority as required by law. And of course, the accountants, we are happy that the Institute of Certified Public Accountants, prior to renewal of the licenses, has also urged the accountants to register. So it is my call at this time to call upon the Law Council and Law Society to rein on the advocates and the accountants to register with the financial intelligence and also to fulfill other obligations. FIA will continue to provide any assistance and outreach. This registration will be, of course, a low-hanging fruit for us to demonstrate that you have been brought under the ambit of the ML safety legal framework. Yeah. Lastly, of course, I want to urge you to start to be avid readers, because there is a lot that goes on in this AML safety framework. You lawyers are avid readers, and I hope you rise to the occasion. In conclusion, I urge you to cooperate with us. We are ready to give you all the assistance that is necessary. And in this regard, I want to invite our colleagues who are going. We have a team of experts here at FIA who will now lead you through the topic for today. Thank you for listening, for God and my country. Yeah, Cynthia and Fiona, you may proceed and continue with.
Thank you, Mr. Bobby, for that background. At least now we are very much aware of where we are coming from and where we are heading. And now at this point, we shall dive into the training for today. That's on the implementation of targeted financial sanctions. And Cynthia is going to take us through the training. Cynthia, you're welcome to take the floor.
Okay, thank you. Thank you, Fiona. Good morning to all the participants who have taken the time to attend this training. My name is Cynthia Mpaire. I work at the Financial Intelligence Authority, and I'll be taking you through the presentation for today. Allow me to share my screen. Okay, so I think just to reiterate the fact that we need each and everyone who is participating in this training to kindly submit their names through the chat, indicating which profession. For example, today's training is covering the legal profession and the accountants. So kindly through the chats, let us know your name, and then which you can just indicate whether you're an advocate or a legal professional or an accountant. Thank you very much. This will help us for purposes of reporting to the international bodies. So, this presentation or training is specifically about the implementation of targeted financial sanctions related to proliferation financing. So we'll cover a bit at length the targeted financial sanctions will be covered at length, but specifically I'll be focusing on those that are related to proliferation financing. So maybe just for you to note that we have two categories of targeted financial sanctions, and that is the targeted financial sanctions that relate to terrorism and terrorism financing, and then those that relate to proliferation financing. So as we go through the discussions, please take note that these targeted financial sanctions will differ. So my presentation will cover, first of all, the FIA's mandate. We'll briefly look at the money laundering offense, the terrorism financing, and the proliferation financing. These are all offenses that are related to the work of the Financial Intelligence Authority. Then we'll briefly, I know David has covered the Financial Action Task Force and the 40 recommendations, but we'll briefly highlight some of those. I will have a brief background on the mutual evaluation and the high-risk jurisdictions for us to have a very good understanding of why it's important for us as lawyers and accountants to know our obligations as regarding the targeted financial sanctions. And then we'll look at specifically, we'll look at FATF recommendation 6 and 7, because FATF recommendation 6 and 7 relate to targeted financial sanctions. So we'll be looking at specifically those two recommendations. And then we'll look at designations. What is a designation? And the designated persons and entity. What does it mean for a person or an entity to be referred to as a designated entity under the United Nations Security Council? Then now in detail, we are going to look at the anti-terrorism regulations of 2023. And these are very important regulations because they establish the procedures on how persons and entities are, first of all, to be designated or declared by the minister, and then how we apply the targeted financial sanctions. So we'll delve into that in detail. So briefly, I'll start with the mandate of the FIA. So the FIA was established under Section 18 of the Anti-Money Laundering Act. And the Anti-Money Laundering Act, basically one of our objectives is to combat money laundering. And those are, the objectives are listed under Section 19. One of them is to combat money laundering through the identification of proceeds of crime, raising awareness on matters relating to money laundering, ensuring compliance of the Anti-Money Laundering Act by accountable persons, among many others. So someone will probably wonder why the FIA's mandate is expanded beyond the Money Laundering Act. You will notice that now when the terrorism financing offense and the proliferation financing offense, when they were criminalized under the Anti-Terrorism Act of 2002, there were a number of obligations that were imposed on the Financial Intelligence Authority in terms of combating or countering terrorism financing and proliferation financing. So when you go under the Anti-Money Laundering Act, you may not specifically find a provision that is mandating the FIA in terms of TF and PF, but you later find them under the Anti-Terrorism Act and the anti-terrorism regulations. So briefly, the mandate of the FIA is to combat money laundering, terrorism financing, and proliferation financing. So these are the three offenses. And maybe to highlight that terrorism financing is an offense on its own. It's criminalized under the amendment to the Anti-Terrorism Act. So this is a different offense and separate from the offense of terrorism or acts of terrorism. Okay, so briefly, Section 3 of the Anti-Money Laundering Act is where the offense of money laundering is criminalized. And this refers to the process of turning illegitimately obtained property into legitimate property. This could include concealing, disguising the nature, source, location, movement of proceeds of crime. So in simple terms, you'd say money laundering is concealing the origins of the illegally obtained money. So you find that these are proceeds of crime and funds have been obtained, for example, from crimes such as corruption, tax evasion, human trafficking, among many other predicate offenses. So you hide the source of that money and then convert it or disguise it to appear as legitimate funds. So in simple terms, someone could say money laundering is making the dirty money, which is from the illegal activities or crimes, then you make it appear clean through the different processes, financial institutions, using the private and public institutions, among many others. Then going to the terrorism financing offense. Now, we want to go so much into terrorism because it is not included as part of the FIA mandate. But we are specifically interested in the TF offense, which involves funds and the movement of funds, use of funds for purposes of committing acts of terrorism. So this offense was criminalized under Section 9A. So you find that the Anti-Terrorism Act was amended in 2015. The original act only criminalizes terrorism and related offenses to terrorism. So the TF offense, you find it under the Anti-Terrorism Amendment Act of 2015. And briefly, this a person who willingly collects or provides funds with the intention or knowledge that such funds are to be used to carry out a terrorism act. And for the offense of terrorism financing, someone can be convicted of this offense, whether the funds are linked to a specific terrorist act or not. So in other words, you do not have to, someone doesn't have to first be convicted of terrorism to be convicted to also secure a TF conviction. So I think the main ingredient is the intention. If the person has the intention, or if it's proved that the person has the intention or knowledge that these funds are to be used to carry out a terrorist act. So that's about the TF offense. And then we'll now have proliferation financing. So this is one of the recent amendments we've had in the MLCFT legal framework. We, during the course of last year, there are a number of laws that were amended, one of which was the Anti-Terrorism Amendment Act of 2022. So this amendment, first of all, criminalized proliferation financing, and then also amended Section 32A of the Anti-Terrorism Act, which empowers the minister to issue regulations. So maybe to briefly describe what proliferation financing is, this is different from terrorism financing. So for proliferation financing, it is where a person or organization makes available an asset, or you provide a financial service, or conduct a financial transaction, and that person knows that the asset, financial service, or financial transaction is intended to manufacture, possess, acquisition, development, transportation, supply, sale of nuclear weapons, chemical weapons, or biological weapons. So basically, this is a person or organization that provides financial services or assets for the manufacture, use, development of these weapons, which have been identified by the United Nations Security Council as posing a threat to international security. So it's a major concern internationally, and therefore there are now standards or measures that countries have to put in place in order to be able to deal with this kind of financing. So you realize that this is not, I think the key term here also is financing the proliferation of weapons. Those are two different things, because proliferation will mean that you're spreading the use, the manufacture, production of these weapons. But then the financing aspect now means that you're providing financial assistance through assets or financial services and transactions to be able to either support or facilitate entities or individuals that are producing these nuclear weapons. So I think that is briefly about, I just wanted to give that background, because we'll be looking at these offenses as we go through this training or have the discussions. And I think it's important to note that all these have an aspect of the offenses, all of them have an aspect of funds or assets or property that is included. And that is why it is tied to money laundering, because you realize that the Financial Intelligence Authority, if you look at its powers, that it collects financial data for analysis and then dissemination to law enforcement to be able to follow the money. So in all these offenses, there's a money aspect that either has to be followed for purposes of money laundering, or it has to be for purposes of TF and PF. How do we obstruct the moving and using of these funds? So now let's go on to the Financial Action Task Force and the 40 recommendation. So I want, since David has covered this, I will just briefly maybe look at generally what the standards are about. So first of all, the Financial Action Task Force is an international body that sets international standards on money laundering, terrorism financing, and proliferation financing. So the standards are to ensure that there are measures in place in each of the jurisdictions. There are legal, regulatory, and operational measures, whether in our laws or institutions, so that we can combat these crimes. And the reason why it is an international standard is because of the nature of these crimes. The nature of these crimes is such that they are transnational crimes. The funds will move across borders. So the purpose or objectives of the FATF is to ensure that each and every jurisdiction and country has strong MLCFT measures in place to ensure that they combat these crimes, because for example, if I give an example of our neighboring countries, if Uganda has strong MLCFT measures, but for example, DRC or Tanzania does not have, then it creates another gap or loophole, because the funds will always be moved to another jurisdiction to either be laundered or support activities or acts of terrorism. So that is why it is a global fight against all these crimes. And therefore we have international standards that all countries have to comply with in order to combat money laundering and terrorism financing. So now the standards are provided in form of the 40 recommendations. So the 40 recommendations address different aspects that the countries have to they have to either include in their laws or in their systems to prevent money laundering and terrorism financing and PF. And yeah, so I think briefly, let me say that about the FATF and the 40 recommendations. We shall not go through the 40 recommendations in details, but we shall look at the recommendations specifically that relate to targeted financial sanctions for purposes of this training. And then maybe at another stage, we shall look at, all the 40 recommendations. But maybe just to mention that the recommendations that relate specifically to terrorism financing and proliferation financing are recommendations 6 and 7. And these are the recommendations that deal with the targeted financial sanctions that we are going to look at in detail. So you find that it's about either 3 or 4 of the 40 recommendations that relate to TF and PF. And most of these other recommendations relate to money laundering, how to combat money laundering. So mutual evaluation. So obviously the objectives of the FATF is to protect the integrity of the international financial system. And so how does it do this? So it will assess countries. So because the FATF 40 recommendations are in place, but then now they have to assess the countries through what is called mutual evaluations. And the mutual evaluations are basically to assess a country on compliance, firstly on 2 aspects. One is on compliance with the 40 recommendations. How are the requirements of these 40 recommendations? Has the country complied? Has the country included some of these requirements in the laws? Do our institutions have powers for investigating, for example, money laundering, TF1? So you find that these ones are basically, it's to assess the technical compliance in terms of our laws strengthened in terms of MLCFT. Are they adequate enough? And then the second aspect is to assess the effectiveness of the country's MLCFT system. So first of all, the compliance is assessed based on the 40 recommendations. Then the effectiveness, so the country will also be assessed in terms of how effective now is this system in terms of combating money laundering and TF and PF. Are there components for an effective MLC system? Are we realizing what we call the immediate outcomes of an MLCFT system? So you find that the FATF has also come up with 11 immediate outcomes of an effective MLCFT system. So there are 40 recommendations, but the 40 recommendations should be able to help us achieve or realize the outcomes. And we'll look at the outcomes, for example, that relate to targeted financial sanctions. One of the outcomes is that the terrorists or terrorist organizations are prevented from, first of all, raising, moving, and then using the funds. So that's an outcome. So once all these laws, we have the procedures, we've established the authorities and the procedures to take us through, to have an adequate legal system. Then we see how functional that legal system is, how effective is it. So member countries are also assessed on that aspect. And then they will identify, are there deficiencies in a system of this country, in the MLCFT system, etc., etc. So these are what we call mutual evaluation. So it's done for all the countries. And then now that's what takes us to identifying high-risk jurisdictions. So the FATF will identify high-risk, jurisdictions under increased monitoring, and then the high-risk jurisdictions. So we'll have 2 lists. The FATF always publishes these documents every year. There's a blacklist, there's a gray list. So the blacklist is for the high-risk jurisdictions, and the gray list is for the jurisdictions which are under increased monitoring by the FATF. So the difference between this is the high-risk jurisdictions are those jurisdictions, like David said, they are not cooperative in terms of complying with the 40 recommendations. They have serious deficiencies in their MLCFT systems. And when a country is listed on the blacklist, then the FATF will call upon all the member countries to now apply enhanced due diligence measures on these countries in terms of having strict, increased scrutiny on financial transactions, for example, that are leaving these high-risk jurisdictions. so that they prevent the risks that are within these jurisdictions from emanating and going through other countries. Now we have what is called the jurisdictions under increased monitoring. These are jurisdictions that have deficiencies. They have strategic deficiencies in their MLCFT system. They have strategic deficiencies, but they are working, they are cooperative with the Financial Action Task Force. They're actively working with them to be able to address those deficiencies. So at the moment, that is what Uganda is doing. After our mutual evaluation was conducted and we were assessed both on the FATF recommendations and the effectiveness, then they identified the deficiencies. And probably I may not have to go through the entire process, but because we're not able to address those deficiencies within the required time according to the procedures, then Uganda was placed on the gray list. This was in February 2020. But then Uganda is now under the gray list because it's actively working with the FATF. We came up with an action plan, agreed action plan on which actions we should address to be able to now address the deficiencies. So now that's the background that brings us now to the main purpose of this training, which is the targeted financial sanctions. And why is this important? Because there were deficiencies that were identified relating to immediate outcome 10 and 11, which relate to targeted financial sanctions related to TF and PF. So that is why we are having this training. And then we actually now amended our we issued the anti-terrorism regulations to be able to now include provisions of implementation of targeted financial sanctions so that we can address these outstanding deficiencies in our MLCFT system. So, targeted financial sanctions. We talked about the FATF recommendations. Each recommendation is on a specific measure, if I may say. So specifically 6 and 7 are on targeted financial sanctions. This, by the way, maybe just to let you know that you can visit the Financial Action Task Force website and be able to access this document. There's a document on all the FATF recommendations, the 40 recommendations, and you can read them in detail because I may not have the time to cover each in detail. So now 6 and 7, recommendations 6 and 7 on targeted financial sanctions. And someone could ask, what are targeted financial sanctions? So in the FATF glossary, which is like the definition, what the lawyers call the definition section, defines what targeted financial sanctions are. This means asset freezing and prohibitions to prevent funds or assets from being made available for the benefit of designated persons and entities. And we are going to look at what it means to be, what designations mean and what designated persons are. But in the literal meaning, targeted, because these sanctions are targeted to those persons or entities that have been designated by the United Nations Security Council. So that's why they are called targeted financial sanctions. And in simple terms, you can say it's the freezing of funds or other financial assets or economic resources of these individuals, groups, entities, including funds that are derived from the property owned by this person. So the major aim is to cut off the channels, the flow of funds, the use of these funds to commit these crimes. So that's why now the freezing aspect in, and we freeze the funds, the property, the assets, by these persons. So that is what targeted financial sanctions mean according to the FATF glossary. So obviously, what is the objective of the targeted financial sanctions? It is to stop the flow of funds and other assets to terrorists, terrorist financiers, and proliferators or its financiers, as required by the United Nations Security Council. So, like I said at the beginning, that terrorism financing is different from proliferation financing. So we are stopping the flow of funds that can be used to commit either TF or PF. Now, this is usually done by the United Nations Security Council through adopting of resolutions, and these resolutions are targeted either for terrorism or relate either to terrorism or TF or relate to PF. So there are specific resolutions that are adopted by the United Nations Security Council. But then also the Security Council depends on the requests for designation from member countries. So it does not only rely on its own designations. So a member country can request a person or entity to be designated by the United Nations Security Council. So this is where our role comes in, because our jurisdictions within Uganda, a person can make a request through the minister for designation of an individual or an organization or entity. So it is two-way. We can have a designation by the United Nations Security Council or designations for member countries. And we are going to look at this in detail under the anti-terrorism regulations of 2023. Now, it is also a requirement that countries should establish an authority and have effective procedures in place on how to propose persons or entities to Security Council for designation. And this has to be in accordance to the United Nations Security Council resolutions, which impose the targeted financial sanctions. So these resolutions have the criteria that you're supposed to follow to either propose or designate persons or entities. Okay, so maybe at a later stage, the FIA will kind of provide details on these Security Council resolutions and what is the criteria that is followed under each of these resolutions. So basically, if we go to recommendation 6, the difference between recommendation 6 and recommendation 7 is that recommendation 6 deals with targeted financial sanctions related to terrorism and terrorist financing, and then recommendation 7 deals with targeted financial sanctions related to proliferation financing. Sorry, that is an error. That has to be proliferation financing. So that is the difference between the two recommendations. The requirements are the same, but 6 deals with terrorism and terrorist financing, and 7 deals with proliferation financing. Now, under recommendation 6, what are the requirements by the Financial Action Task Force? The first requirement is that countries should implement targeted financial sanctions to comply with the United Nations Security Council resolutions relating to the prevention and suppression of terrorism and terrorist financing. So there are resolutions that relate to the prevention of terrorism and terrorist financing. One of the resolutions is resolution 1267 relating to Al-Qaeda, which is a terrorist group. And then there's another one that relates to the Taliban. So there are these resolutions that are adopted that relate probably to a terrorist organization. And then they highlight the targeted financial sanctions that must be imposed in that regard. So now countries have to implement, what is required is that we also implement these targeted financial sanctions from these resolutions. And then secondly, the resolutions require countries to freeze without delay. I think we should take note of the terms without delay. The funds and assets of any person or entity that is designated, and ensure that no funds or assets are made available for the benefit of any person or entity that is designated. So those are the two requirements under recommendation 6. One is to implement these targeted financial sanctions, and then to also freeze the funds or assets of the persons or entity designated. So in the same vein, section 7, it's also about targeted financial sanctions, but this time relating to proliferation financing. So countries again should implement targeted financial sanctions to comply with the Security Council resolutions relating to prevention and suppression of proliferation of weapons of mass destruction and its financing. So we looked at the definition of what proliferation of weapons is under the Anti-Terrorism Amendment Act of 2022. So this is currently criminalized in Uganda. And then secondly, the resolutions also require that countries freeze without delay the funds or assets of any person or entity designated, and ensure that no funds or assets are made available for the benefit of these designated persons or entities. So we have to take note of the key requirements of this, which is to freeze funds and assets. And all of us as accountable persons have a role to play. We have obligations as we look at them under the regulations of 2023. So that is why we need to know what targeted financial sanctions are. What is my role as an accountable person? What is the role of the Financial Intelligence Authority? What is the role of the Director of Public Prosecution? What is the role of other public and private bodies and entities? All of us have a role to play. So briefly, that is what the recommendations are about. Okay, so we've talked about having persons or entities being designated by the United Nations Security Council. So what does this mean? What does it mean to be designated as a terrorist or a terrorist organization or a suspected terrorist? This again is defined in the FATF Financial Action Task Force glossary. The glossary is at the end of the recommendations. It's one booklet, which is the definition section. And briefly, this refers to the identification of a person, individual, or entity that is subject to targeted financial sanctions pursuant to the United Nations Security Council resolution. So this basically means that the United Nations Security Council resolution will identify, for example, like I said, the Al-Qaeda or the Taliban, and then it will now have or prescribe which targeted financial sanctions are related to these resolutions. For example, under the resolution maybe 1267, the FATF requires that a person or organization that facilitates or finances or supports activities, for example, the Al-Qaeda is also identified. So this could be a person, this could be an individual, this could be an organization, this could be an entity. So you find that if you're supporting activities as, you know, or associating with this terrorist organization, you're required to be identified and designated as a suspected terrorist. So briefly, that is to explain it. So here they just identify persons, individuals that should be subject to the targeted financial sanctions. So the designated person or entity. Now these are individuals, groups, and entities that are designated by the United Nations Security Council. Pass you on to the relevant resolutions. We've talked about Al-Qaeda, we've talked about Taliban. These specifically relate to terrorism and terrorist finance, but not to PF. So like I said, there are different resolutions. So that is what we call a designated person or entity. So you're designated either as a terrorist, a suspected terrorist, who look at it, or a terrorist organization. And then it could also be a natural or legal person or entity that is designated by jurisdiction. Because like we said, also member countries, the law requires, or the law provides, that the member country can request for designation, can make a request through the Minister of Internal Affairs, can make a request to the United Nations Security Council to designate a person. And obviously this comes with supporting documents, information, to having reasonable grounds or indicating reasonable grounds why that person is suspected as a terrorist organization. So briefly, and once again, it is either those that are designated by the United Nations Security Council or those that are designated by member countries or jurisdictions. So before maybe I don't know if Ivan, the moderator, is on, but I would like to give members a 10 minutes break, then we'll now delve into the anti-terrorism regulations of 2023.
Yes, thank you, Cynthia. That's fine. We can have a short break. That means we'll be back 10:34 a.m. Let's say 10:45 a.m. And yes, thank you. So we'll resume then. Just a short break. Hello, I think our short break is done, so we can now resume. I request that if anyone has a question, we have a Q&A section on Zoom that can allow you to raise your question, and one of the panelists will be responding to you. Thank you. Over to you, Cynthia.
Okay, thank you. Thank you very much, Ivan. And yes, like he has just said, I've been advised that all the questions, please submit your questions through the Q&A. And then we have different panelists that are on to answer all your questions. They are online, and yeah, they're experts in this MLCFT field. So feel free to ask your questions as we proceed. So the next section of this training is about the anti-terrorism regulations of 2023. These are fairly new regulations. They've just been drafted and issued, and specifically to address these deficiencies that are relating to targeted financial sanctions. So these regulations specifically relate to targeted financial sanctions, the regulations of 2023. We also have the anti-terrorism regulations of 2016 that covers, other provisions of the principal law. And then we have the 2023 now that is addressing the targeted financial sanctions and the related procedures. So earlier on, we had gone through the reasons or the objectives of these targeted financial sanctions. What purpose are they intended to achieve? And we also looked at the fact that countries have to establish authorities and then measures or procedures in place on how to implement the targeted financial sanctions. So this is the document that prescribes all the procedures that are related to targeted financial sanctions. These regulations, you can visit the FIA website. You'll be able to find them for your own purposes of reading. You'll be able to find them on our website. And so basically what I'm going to cover for the benefit of time, I may not go into all the provisions of the regulations, but I'll cover the areas and then that relate to our role as accountable persons and the Financial Intelligence Authority. So I will mainly focus on those, but by the time we leave this training, we exactly know what is our role in this regard. So I will cover the declaration of the terrorist organization. That is from about section 3 to section 6. And then there's also designation of individuals as terrorists or suspected terrorists. That is also from section 7 to about 7 and 8. And then you find that there's declaration of persons or organizations under the Security Council resolutions. So the first two aspects are for declaration by the minister. The declarations are made by the Minister of Internal Affairs. So what is the procedure in terms of declaration of terrorist organization, and also the procedure in terms of declaration of individuals as terrorists or suspected terrorists. Then the third aspect is about declaration of persons or organizations under the United Nations Security Council resolution. So they are already those persons or entities or organizations that have already been declared by the Security Council resolutions, designated by the Security Council resolutions. So how does the jurisdiction declare these persons within our own context as a country? And then what is the process of ensuring publication of these lists to both the private and the public sector. And then we'll look at the freezing and seizing of the funds or property of that designated persons and entities. And then we'll look at dealings in frozen or seized funds or property. So those are the 5 major components that we'll be covering. So if we look at regulations 3 to 6, cover the procedure of declaring a terrorist organization. And it provides or empowers the Minister of Internal Affairs. The Minister of Internal Affairs is responsible for implementing the Anti-Terrorism Act. So the minister is empowered to declare an organization as a terrorist organization. So there's a whole procedure, but I'll just summarize it for you. So under this procedure, a foreign person or a foreign state or even an international organization may make a request to the minister to declare an organization as a terrorist organization. So this request will be in writing to the Minister of Internal Affairs. It will contain particulars on the organization in terms of identification, to be able to identify the terrorist organization, and then also probably the location. And then the request should also have grounds as to why you believe the organization should be declared as a terrorist organization. And then you have to state the funds or the property of that organization. So it is a detailed request. It has to have all this information. Now, when the minister receives this request, the minister will request the Inspector General of Police to examine the request and then advise the minister on whether there are reasonable grounds to actually declare the organization as a terrorist organization. So it will be the role of the Inspector General of Police to identify if there are reasonable grounds for declaration of this organization. And then the IGP may also now request for additional information to be able to determine, to make a determination as to whether there are reasonable grounds. So the IGP will either collect additional information from state authorities, from supervisory bodies, from regulators, from accountable persons, from the Financial Intelligence Authority, DPP, or other law enforcement agencies. So the IGP has that power under the regulations. Then the minister will, after considering all this information and the advice that is provided by the IGP, will make a determination on whether actually these are reasonable grounds to declare an organization as a terrorist organization. And when they've made that, when he or she has made that determination, they will then declare that organization as a terrorist organization. And that declaration will be in form of, there's a form attached. I think it is Form 1 that is attached to the regulations. That is how the declaration, the form it will take. And then the Anti-Terrorism Act, the second schedule of the Anti-Terrorism Act will be amended. If you've looked at the second schedule, this is where the law provides for the list of of terrorist organizations or organizations that have been declared as terrorist organizations. So far, there are 4, to the best of my knowledge, and one, if you look at the ATA of 2002, one is the Lord's Resistance Army. It has been declared as a terrorist organization. The Lord's Resistance Movement, ADF, is also listed, and Al-Qaeda. So you find that now if there are any new declarations, that second schedule has to be amended so that they are included. So what happens after we've now declared the terrorist organizations within our jurisdiction? The minister will then notify the United Nations. He will notify the United Nations of the declaration that has been made within the jurisdiction, and then will now make a request for the United Nations as well to designate this organization in accordance to the Security Council resolutions. So it does not end at the organization being declared within the jurisdiction, but then the minister also has to inform and notify the United Nations Security Council so that it's also designated as a terrorist organization. Now, there's another aspect on review of the decision of the minister. The minister's decision on declaration can be reviewed. And this is, I'm looking for the specific provision under the law. I think it's still regulation 3. But here we find that a person or an organization for this purpose that has been declared may apply to the court to review the decision of the minister. To review the decision of the minister, and the court will take into account a number of factors in arriving at its decision. So that you also find that provision there. It's under regulation 6. So the court may actually set aside, the court has powers to set aside a declaration made by the minister. And this will be, the grounds are listed there that the court has to take into account before arriving at that decision. One of them is that if the court determines that there were actually no reasonable grounds for the declaration of that terrorist organization, or secondly, that the grounds that the minister based his or her decision no longer exist. And then also, in case there is new information that has come to the attention of the court that there is a change in the behavior of the terrorist organization. So in those 3 circumstances, the court may set aside the decision of the minister. So that is provided for under regulation 6. Then we'll go to the other section on declaration of individuals as terrorists or suspected terrorists. This you find it under regulation 7 to 9. So for individuals, they can be declared in 2 categories, either as terrorists or suspected terrorists. And the law goes on to prescribe which individuals can be declared as terrorists and which can be declared as suspected terrorists. So when you look at regulation 7, for an individual or a person to be declared as a terrorist, that person should have been convicted of an offense under the Anti-Terrorism Act. At the beginning of this training, we looked at the different offenses that are under the Anti-Terrorism Act. So you find that there is terrorism, there is terrorism financing, there's proliferation financing. All those are offenses under the ATA of 2002. So where the person has been convicted of that offense, that person can be declared by the minister as a terrorist. And that is the only ground for declaring an individual as a terrorist. Then declaration of suspected terrorists. The Act provides a number of circumstances under which a person can be declared as a suspected terrorist. One of them is, for example, if you are a member of a terrorist organization, that is one. If you have attempted to commit an act of terrorism, or you have participated or facilitated, aided or abetted the commission of an act of terrorism. And then if you have also, like we looked at some of the resolutions earlier on, if you have facilitated or supported or you're financing activities of some of these already designated terrorist organizations, for example, Al-Qaeda or Taliban, then you can also be a suspected terrorist. So the list is long. If you look at, probably in your free time, you look at Regulation 7, and you'll be able to distinguish the grounds for declaration of suspected terrorists. But the only ground for declaration of terrorists is if you've been convicted of the offenses under the Act. And then so you make a request as well. So those provisions are just empowering the minister to make those declarations, I beg your pardon. However, a person or a foreign state or international organization still can make a request to the minister to declare a person as a terrorist or a suspected terrorist. And the procedure is the same. It should be in writing, accompanied by those documents, accompanied by the grounds as to why you believe that this is a terrorist or suspected terrorist, and the nature of funds, details about the individuals, etc. And then the IGP will have to examine this request. Then we talked about the IGP requesting for additional information from accountable persons, FIA, reporting entities, authorities, that will help him to make a determination as to whether there are reasonable grounds. Then as well, you make a request once these individuals have been declared as terrorists and suspected terrorists, you have to also request now the United Nations to designate them as terrorists. There is also a provision on review of the declaration, and that's under, I think, regulation. That's under Regulation 8. The court has powers to review the decision of a minister. So any individual that has been declared as a terrorist or suspected terrorist can apply to the court, and the court will consider the same factors in arriving at a decision on whether to set aside the decision of the minister or to uphold it. Okay, so now, so we've looked at, previously we've gone through now the declarations of terrorist organizations and terrorists. So we have to keep in mind that all these are different offenses. So I believe for purposes of these discussions, because we are looking at the financial, targeted financial sanctions relating to proliferation of weapons of mass destruction. So now, if you look at section, regulation, I beg your pardon, that is an error. It shouldn't be section 10. It should be regulation 10. So for declaration of persons and organizations under the United Nations Security Council, notice that after these persons or organizations have been designated under the different Security Council resolutions, then they have to be declared by the minister. So this is like a reversal. So previously or earlier on, we looked at instances or cases where the minister can declare. So now, where persons or organizations have been declared under the United Nations Security Council resolutions, what is the procedure of now declaring them within our jurisdiction? So we'll look at that is covered under regulations 9, 10, and 11. So you find that the minister has to declare that person or organization engaged in the financing of proliferation of weapons of mass destruction. We earlier on looked at the definition. This is the providing of assets or financial services or facilitating financial transactions with the intention or knowledge that they will be used for the development, manufacture, use, and supply of chemical and nuclear weapons, which are a threat to the security, international security. So where a person or organization has been designated for participating in activities of financing of PF, if I may say, so that person has to be declared by the minister as well. And then also the procedure is the same, that any foreign person, state, or international organization can make a request to declare that person or organization as a terrorist or a suspected terrorist or terrorist organization. So for those that are involved in activities of proliferation financing, they will be designated as suspected terrorists. They'll be designated as suspected terrorists or terrorist organizations. I don't know why my screen has, sorry. They'll be designated as suspected terrorists or terrorist organization. And then also the process of making the request and handling the request is the same as the declaration of terrorist organizations and the terrorists. So that whole process of making the request to the minister, how the request is handled, and the procedure of the court to review. And the procedure of the court to review that declaration is the same. So you find all those provisions under Regulation 9. So Regulation 9 is a very significant provision in this law, because it is where we now declare persons and entities that are involved in PF, and then we apply the targeted financial sanctions. So please, I think it is important to take note of that. And then if we move on to so the last cut, sorry. So I think I've covered the designation of proliferators of weapons of mass destruction. That is under Regulation 9. So that specific regulation takes you through the procedure for implementing and declaring a person involved in those activities. So if we move on to now the declaration of persons and organizations under the United Nations Security Council. So once persons and organizations have been declared under the resolutions, the different resolutions that are related to terrorism, TF or PF, So, and Section 10 requires that once the Security Council has made that designation, then the procedure to be followed is provided for under the whole of Regulation 10. Please take note of that error. It's not Section 10, it's Regulation 10. Apologies for that. So the procedure under this is that now what we call the, after a person or entity, for example, Al-Qaeda has been designated by the United Nations, what happens now within our jurisdiction? So we have what is called the Permanent Mission of Uganda. That permanent mission of the Uganda to the United Nations will inform or notify the minister of the particulars of the designation, which entities or individuals have been designated, and the targeted financial sanctions that are to be imposed. So the Minister of Internal Affairs will then notify the Financial Intelligence Authority of the designations, and then automatically declare that person, if I may say, or organization as a suspected terrorist or terrorist organization. So that declaration, the law provides that it has to be made within 24 hours. So if I can take you back to the requirements of the recommendations, these sanctions have to be implemented without delay. And then now our regulations go ahead to prescribe the timelines within which the minister is supposed to declare that person or organization. So immediately within 24 hours, I don't know if this is practical, the schedule has to be amended and probably include other terrorist organizations and the individuals that have been designated by the UN as terrorists. So this declaration is specifically the declarations that we cover under Regulations 10 and 11 are specifically for those persons or entities that have been designated by the United Nations Security Council. Yes, so that is the procedure for declaring those persons and organizations. And so you have to inform. So after FIA is informed, FIA will also inform accountable persons of these designations. And so for designations by the Security Council, this cannot be reviewed by the court. However, there is a procedure for delisting a person from the listed entities or persons. So that procedure is also provided for under Regulation 11. You have to apply to the United Nations to be delisted if you've been designated by the UN. So the court cannot set aside a designation by the UN. That one, the application has to be made to the UN to be delisted, and then that submission can be made to the focal person of the country. So all these procedures are provided for. The request for delisting can also be submitted through the Minister of Internal Affairs. Then the minister will have to review it and submit it to the focal person at the UN. And then the UN will consider whether to delist this person or they maintain them on the list. Okay, so I think let's move on briefly. I think this is, if there's any takeaway from this entire training, it should be the role of you as an accountable person or you as a DNFPB. So now the role of the Financial Intelligence Authority and the accountable persons prescribed under those regulations, 12, 13, 15, and 19. They are detailed in terms of if we have declared individuals or organizations as terrorist organizations, or they have been designated by the United Nations. So what is our role as accountable persons? So briefly, if I may take you through the procedure that follows after the declarations. So after the minister makes the declarations, then they will immediately notify the Financial Intelligence Authority. And the Financial Intelligence Authority will cause what we call a temporary freeze or seizing of the funds of the property, or property that belongs to the terrorist or the suspected terrorist or the terrorist organization. And why it's a temporary freeze is because of the need to apply for a court order. When it comes to terrorist financing, the powers of the Financial Intelligence Authority are limited in that the freezing will, I beg your pardon, once the FIA imposes a freeze on the funds or property of these designated persons or entities, then it will have to inform the DPP, who will have to apply for a court order, a freezing order from the court, and which is different from the money laundering aspect, because under the Anti-Money Laundering Act, the FIA will freeze funds on suspicions, under the powers of FIA, on suspicions of money laundering. So that's a broader power. So now, once that temporary freeze has been imposed on the funds or property of the designated persons or entity, the FIA will circulate this information to all accountable persons who report to us. And this information has to be circulated in an expeditious manner. And the law says it should be within 8 hours after receipt of the notification. So within 8 hours after FIA has been notified, it has to inform all our persons. This we usually do through circulars to the regulators, or even sometimes the circulars are uploaded on our website. Then the accountable person will have to conduct checks and verify details of these declared terrorists and terrorist organizations, and compare to see if these details align with any particulars of their customers or clients. For the sake of lawyers, they may not be customers. Maybe financial institutions will have customers, then the legal profession, the clients. So you have to verify the details of each declared individual or entity with the information or the particulars of all your customers. One of the requirements under the Anti-Money Laundering Act is we must maintain identification, information, or documents on all our customers and clients. So you must verify, look through, and identify if any of this matches with any of your customers. And then determine if you've identified that actually this could be your client, then you have to determine whether you hold any funds or property, or for example, you are conducting a financial transaction on behalf, or you're facilitating a transaction on behalf of this client. So you have to identify all those aspects. And then after you have identified that actually this is my client, you have to freeze the funds or property and stop all transactions that are related to the funds or the property without delay. The law says without delay and notice. And for this specific provision, there is no timeline. that is provided under the law, but it says without delay and without notice to these clients, to these suspected terrorists or organizations. So, because one of the offenses under the Anti-Money Laundering Act is tipping off, and tipping off refers to the fact that you have notified or informed your customer that actually a suspicious transaction either has been reported. So that is an offense. So what the law requires is that you cease all your operations and stop all your transactions with this person without delay and without notice. And then you inform the FIA of the full particulars of the funds and property that have been frozen. So all this information has to be submitted to the Financial Intelligence Authority. So if you hold, for example, funds or property on behalf of your client, or you are conducting transactions, probably land transactions on behalf of these organizations or individuals, then you have to stop all that. And then without informing this person, you must submit all these particulars of the funds and property to the FIA. Now, let me preempt, because I know that especially for the legal profession, they always bring up the advocate-client privilege and confidentiality issues. And we have always addressed that, because in regard to the professional ethics and conduct regulations, the advocates' ethics and conduct regulations. This privilege is provided for there, but it has exceptions. If you went back and looked at it, it has exceptions. And if one of the exceptions is if it's a requirement of the law, then you must comply. You must comply as a lawyer, you must comply as an accountant with the law, regardless of the privileges that are stipulated therein. So I know some people maybe could want to jump to that advocate-client privilege, but it is important for us to note the fact that the law must be complied with, and it's an exception to that privilege. And then, so after you've frozen, you have informed the FIA. And now what information do you submit? Because we need to so probably now the regulation also provides for information that you need to submit to the FIA. And for example, for financial institutions, we have already conducted a training for the banks and other financial institutions. This could include information such as account numbers, the name of the account holder, the balance on the accounts, and then other related accounts and the balances. So you must submit all that information. If it's property, you must be able to submit information on the name or the owners, the holders of that property, that when this property was acquired by the owner, and then the location of the property, and the transactions, other transactions. Are there, is the property being in the process of being sold off, etc., etc. So the information must be that detailed and submitted to the FIA. So then if we move on to Regulation 12, which talks about the funds and the property that are to be frozen. So this is not only funds that funds or property that is owned or controlled by the declared terrorists or suspected terrorist or terrorist organization. This can also include funds that are generated from the property owned by these organizations or these individuals. For example, if the organization owns maybe real estate, and there are funds that are being generated from those real estate projects, these also have to be frozen. Then we also consider funds or property of the persons who are acting on behalf of the declared terrorists, suspected terrorists, or terrorist organization. So you find that in most cases, the property may not be in the names of the actual owner or holder of this property. It could be in the names of third parties. So you must be able to identify the third parties and then freeze the property or funds of those parties that are acting on behalf of the declared terrorists. I don't know, maybe I should give an opportunity to any of the panelists or my colleagues at the FIA if they want to add on something before we go to the dealings, which will be our last segment of the training. So I don't know if Fiona, David, Bright, anyone online in regard to what we've covered so far in terms of the procedures following the declarations, the freezing of funds and properties and assets. And now, before I move on dealings in these frozen funds or property. If there are no, okay, maybe they will give their remarks or shots at the end of the training.
Cynthia, you can proceed.
Cynthia.
The questions are being responded to in the chat.
Okay.
Yes,
right.
and this is Brenda. I just wanted to say that generally, I believe we are progressing well. We have been attending to the questions that have been dropped in the question and answer section. Members are really participating and contributing. And I believe that we should make room for an elaborate Q and answer session at the end for at least 20 minutes. We should reserve 20 minutes for questions and answers. Thank you.
Okay. Okay, thank you, Brenda. All right, so let me proceed. So the next provisions really relate to the dealings in these frozen funds or property. And this is covered under regulations 12 of the anti-terrorism regulations. So I highlighted regulation 12 because it is very important and key for us to note as accountable persons. It provides that an accountable person shall not permit any dealings in respect of the funds or property the FIA has directed should be frozen. So these are funds or property of the designated terrorists or terrorist organization. So you as an accountable person should not permit any dealings. At that point where the individual or organization has been declared, then you stop all the dealings and transactions that relate to those funds, to the funds and the property. And then secondly, we have just a minute. Yes, so there's also regulation 1210C, which is very key, that the accountable person shall not have any dealings with a declared suspected terrorist organization, including making funds or property available, making economic resources or financial services available for the benefit of those entities. So the first the first prohibition was on the accountable person not having to deal with the funds or property. Then this particular requirement is that the accountable person, you do not have to have dealings with the declared suspected terrorist or terrorist organization. And this includes not making the funds or property available to these entities. So that is what we mean by freezing or seizing the funds or property and then reporting it to the FIA. So it is important for us to define dealings because the regulation talks about dealings in these funds or property belonging to these designated entities. So Regulation 2, which is the interpretation clause, defines what dealings mean. And this is the receiving, acquiring, transacting, representing, concealing, transferring, moving, using, providing financial services. So you're dealing with the property, you're either in the process of transacting, because the FATF recognizes advocates and accountants as middlemen in these transactions. They have a role to play in these transactions. So in the process of transacting and acquiring property and transferring or even concealing it so that it is not frozen or dealt with according to the requirements of the Security Council, is what we mean by the term dealings. And Regulation 1211 makes it an offense if you contravene the specific provisions that are prohibiting you from dealing with the funds or property or these designated entities, then you commit an offense, and the regulations prescribe the penalty, which is imprisonment not exceeding 6 months. So briefly, we can talk about the freezing orders. I talked about the fact that the DPP has to apply to court for freezing orders when these funds or property have been temporarily frozen by the Financial Intelligence Authority. So that is provided for under Regulation 13. And then it is important to note that these funds or property have to remain frozen until the court makes a determination. So so it means that the funds or property cannot be dealt with at that point in time until the court decides on the matter. And so Regulation 15.2 is also an offense. If there are any dealings related to funds or the property of designated entity that takes place while the court is still determining the matter, it will be an offense under the Act, and there's a prescribed penalty under that Act. So briefly, that is it about the freezing order. So the FIA will have to inform DPP after it receives all the information from the accountable persons on the designated entities, the nature of the funds and the property they hold, and all the information we looked at that must be submitted to the FIA. Then the FIA shall now, within 48 hours, the law provides that within 48 hours, you notify the DPP who makes the application to court for a freezing order. So we also have Regulation 19, which is important because there are circumstances the law has provided where the court can grant permission for you to deal in frozen or seized funds or property. So under Regulation 19, a person who wishes to have any dealings with the funds or property that is frozen, you must make an application to court. And the court is empowered to permit dealings in the frozen or seized assets on grounds that it considers appropriate. So there are a number of grounds that are listed in the regulations that the court has to take into account before it actually permits dealings in these frozen for seized assets. And so before the court makes that order, the court must look at a number of factors. And one of the factors is that if the funds or property are necessary to cover what we call the basic or necessary expenses of the terrorist or terrorist organization. So the regulation defines what basic or necessary expenses are under Regulation 2. And this basically means expenses to cater, for example, for the basic necessities, such as food provisions, such as medical attention or medical treatment, such as housing or rent, such as taxes, and also includes the professional fees, if I'm not mistaken, for the provision of legal services as a basic or necessary expense. Because you realize that once some of these individuals or entities or organizations are declared or designated by the UN, they will have, obviously they may have charges that are imposed on them, either terrorism or TF or PF, and they will have to go through the legal procedures. So the law has covered professional fees for provision of legal services as a basic or necessary expense. The second factor is the funds or property that are necessary to cover what we call the extraordinary expenses. So these are expenses that they're not the basic necessities, but the law has said that are required and are of importance to the organization or the individual, the designated individual. Then funds or property that are subject to judicial judgment or administrative judgment. So that will also, the court will permit dealings, in case the judgment is given in your favor and you're a judgment creditor, so that you can apply to court to permit dealings in this frozen funds or property. Then lastly, if the frozen funds or property are payment for contracts, under contracts that were entered into before these individuals or organizations were listed or designated by the United Nations. So you find that this should be a contract, first of all, that was entered into before the designations took place, and then their contractual obligations and the funds or property have to be used as payment. So those are some of the factors that the court will take into account. So for cases where, for those individuals or entities that are designated the United Nations, access to the funds or property shall be granted by court, but upon approval by the Security Council. So where the individual organization was designated initially by the United Nations Security Council, so the court does not make a final decision on that, it will have to be upon the approval of the Security Council. So I think it's important to note that. So those are the grounds to permit the dealings. They are covered under Regulation 19.3 of the 2023 regulations. So what happens when the court has permitted the dealing in the frozen funds or property? So at this point, the FIA will notify the specific person or organization, will notify them of the court decision or the court order. And then the accountable person shall take reasonable measures to implement the decisions of the court. Because remember, as an accountable person, you are holding either property or funds in trust for some of these persons, listed persons, organization. So you have to comply with the court order and take the reasonable measures to implement the decision. And the accountable person will have to report to the FIA on the manner in which the funds were used or disposed of. The minister will have an obligation to report to the Security Council. So there will be, once the decision is made by the court, there will be, you have to notify, first of all, the FIA, and then the minister at that level will notify the Security Council on how the funds are being used or disposed of, because to avoid the funds now being used for the activities for which these people were designated or listed. So we have to follow through on how the funds have been used and take note and account of that. Now, under Regulation 19.9, Sub-Regulation 9, it can revise its decision on permitting dealings in the frozen assets or property, if there are reasonable suspicions that the funds were used for terrorist financing or financing of proliferation. So in case there is evidence or reasonable grounds to prove that the funds again have been used to commit these crimes, then the court will reverse its decision and the funds are frozen at that point. Now, lastly, how the designated persons or organization, it talks about publication of these designated persons or organizations. As accountable persons, we need to know how shall we be updated on the designated persons, the developments on the listed persons or the listed organizations. And this is covered under Regulation 23. So where the minister declares or the person is designated under the UN, or there are any delisted entities, the minister must publish all this information in the Uganda Gazette or in a newspaper of wide circulation. So every time there is a change on, for example, the list of terrorist organizations, this will have to be published in the Gazette. And it is the responsibility of accountable persons to take note of this information on the changes. Like I said, because the timelines that are provided within the regulations are very short timelines. We looked at the fact that you must amend, for example, the second schedule within 24 hours after a person or entity has been designated by the UN, within 24 hours. Then accountable persons within 8 hours, after the FIA has informed you. This is quite a short period of time. But another mechanism we have is that we publish these lists on the FIA website. So the minister will publish them in the Gazette so that we also inform the accountable persons in time. We issue these circulars on the FIA websites in time so that you're able to act within the timelines provided by the law. Yes, I think with this, I come to the end of my presentation. I don't know if, so those are just maybe to clarify that this presentation has focused really on the role of accountable persons in terms of implementing the targeted financial sanctions and freezing assets and property of those individuals or entities that have been designated either by the UN or by the minister. So that has been the focus. The regulation, you can, in your own free time, read them in detail to have a wider view and comprehension of the targeted financial sanctions. There are some sections provisions we may not have covered, but at least the role of the accountable persons and the FIA has been covered in depth, and probably in your own free time, you can go back and review these provisions of the law. So that is it about the targeted financial sanctions. These are new provisions that have just been introduced in the regulations this year. And I believe we, as a regulator, we are going to start implementing these requirements of the law. Where the accountable persons have to act, it is important that they act within the timelines that are provided for the law. And most importantly, like we highlighted at the beginning of this training, is the fact that Uganda needs to exit the gray list. And if one of the action items relates to targeted financial sanctions, and all of us have a role to play. So like David indicated that we have covered most of the action items on the ICRG list, and they are outstanding items, and this is one of the major outstanding items on targeted financial sanction. So the purpose of this training is to actually enlighten you about what is your role, what you have to do, where can you find these listed persons, designated persons, suspected terrorists and terrorist organizations, so that you have a better understanding on how to comply with the law and your obligations in that regard. So thank you so much for your time. Thank you for sparing the time to attend this training. I believe that we haven't gone through the United Nations Security Council resolutions in detail, because it would take up quite a lot of time, because there are resolutions that relate to terrorism, terrorist financing, and PF, proliferation financing. But God willing, at a future date or what, I think we'll discuss now these resolutions in detail, or FIA will compile the requirements under these resolutions that have been adopted and the criteria that is taken into account by United Nations to designate terrorists and terrorist organizations, and maybe publish, maybe, I don't know, upload it on the website for purposes of your compliance and also understanding of these matters. So thank you very much. I hand over to Fiona or Ivan. Again, I believe that some of the questions are being answered in the Q&A by the other colleagues, FIA colleagues online. So please, if you have any question, especially in regard to what we have covered on targeted financial sanction, the scope of this training, please just send through the Q&A and we'll answer. I think we can go. I don't know if we should have a break of 5 minutes, then come in and now deal with the questions. Fiona can guide us.
Yes, Cynthia, that's okay. That's very okay.
Okay, I think we can have,
as we try to scan through the questions, then come back for the final session.
Okay, thank you very much.
So even I think you can calculate for those using for them simply like that we take off a bit of those issues. You are maybe some
All right. Let's resume with the questions. I note that most of them have been answered in the chat. But as we wait on the rest of the questions, we are pleased about the active participation of members, which we have seen in the chat. There are so many questions that have come up. And allow me to thank Cynthia for that wonderful presentation. I'm very certain that people now know what targeted financial sanctions are and their responsibilities in terms of responding in the event that they have a client or a customer who is a designated person. So this calls on for all of us to take precautions in our dealings, and once the information has been disseminated by FIA, to cross-check on the list of our clients to see if there's any positive match of whoever has been designated as a listed person on the sanction list or an entity. So in the event that you find out that you have a positive match, then that's when you're supposed to inform FIA, as Cynthia has mentioned, within the shortest time possible, as soon as possible. And this calls on for all members here on the platform to have put in place measures like screening measures, that is the sanction screening, for purposes of identification of whether you're dealing with the right people or designated people or people that are originating from jurisdictions that are performing proliferation financing related activities. It's very important, because those are the red flags that can give you an indication that you're dealing with the wrong person, and you file a suspicious transaction or report to FIA that I'm dealing with a person who is coming from a country, a proliferation country, or you engage the client to find out if you're dealing with the right person. So that's what we call screening a client, to see that you take the necessary precautions to ensure that you deal with the right clients. So you must take note of all the red flags, the indicators that can give you a hint that you're not dealing with the right person. That's why we are here today. And as we wait for other questions in the chat, so currently there is no question in the chat. But yes,
there's a question. There's a question that I need to clarify on. First of all, most of the participants have indicated whether the presentation will be shared. Yes, it will be shared with you, to just clarify that and then confirm that. And then there's a question on what happens when the FIA wrongly free accounts. Is there a remedy? Yes, there's a remedy. The regulations have provided have a provision on that. It was not covered in my presentation, but probably for the sake of the listeners, if you read 14, you will it talks about funds or property that is frozen in error. So in such a case, the FIA will have to immediately notify the DPP, and if the property has been frozen in error, and the DPP will obtain a court order, because we still have to go through this of obtaining the court order. So that once the FIA has notified the DPP of the funds that have been frozen in error, then the DPP will obtain a court order to authorize FIA to lift the freeze. So because the freeze is imposed by the court order, then we also have to go through the entire process of obtaining a court order to immediately lift the freeze. There's been many questions of beneficial ownership, which I cannot really cover because I don't know. And I believe that URSB has done a number of trainings on beneficial ownership, and we shall continue to work with them, because this is still a relatively new concept in the MLCFT kind of legal framework, but we shall hold more trainings on beneficial ownership to enlighten our understanding on that. There's also been a question by Isaac on the presentation gives the impression that where there is a simultaneous prosecution, where an accused is convicted of TF and the anti-corruption court finds prosecution has failed to prove the offense. So maybe, I don't know if I understand the question well, but the convictions or charging and trying and convicting these offenses is totally different from the criteria applied in targeted financial sanctions or in listing and designating these entities. So under the standards which form the basis for our laws, like I said, the Security Council resolutions have specific criteria to guide on how a person or entity can be designated as a terrorist organization. So like I said, you do not have to first of all prove and be convicted of the offense, because what we are aiming at or driving at is the funds and assets, and how should we be able to stop the flow of these funds or from being used to commit acts of terrorism. So by the time we go through the court procedure of trying the case, evidence here and there, I don't know, the funds probably will be, or property will be transferred, and therefore will not, achieve the objective of why targeted financial sanctions are there. So the targeted financial sanctions are there, first of all, to hold the funds and the property, that you have reasonable grounds, and the criteria will in detail lists. And if you look at actually the document, the 40 recommendations, if you look at the interpretive notes to each of the recommendations, you find that these Security Council resolutions have been listed under criteria for listing persons and organizations, and then applying the targeted financial sanctions is provided for. So we must know the intention of having these targeted financial sanctions in place is to target the funds and the property that is being used to advance the commission of these crimes. So we do not have to go through the entire court process until conviction. So I just wanted to clarify that to Isaac. I don't know if it answers his question. And I think most of the questions have been answered online. I think that's it from me. I don't know if my colleagues have any questions they want to respond to. Thank you.
Okay. Thank you, Cynthia, for that. And I would like to add that the purpose of the targeted, implementing the targeted financial sanctions is to combat terrorism financing and proliferation financing. And the motive in this is to disrupt the activities of the terrorists from financing terrorism or proliferation financing. So we need to put in place safeguards to ensure that we deal with the right people. We don't deal with the wrong people who have been designated. And these safeguards may include the KYC controls that you need to put in place, screen the clients that you have to satisfy yourselves that you're dealing with the right people who are not designated, and get adequate information from the clients, because that is what the law requires, the Anti-Money Laundering Act. Please note that how anti-money laundering can result into terrorism financing, because the illicit proceeds, the illegal proceeds that are obtained from criminal activities can still be used to finance terrorism. So how we are going to make sure that we deal with the right people is by putting in place the necessary controls, having the policies in place to guide us on the implementation of these laws, doing adequate customer or obtaining adequate customer due diligence information from our clients. I know we are quick to take on business from our clients as law firms. We are after the business, and that we understand. But however, obtain adequate information to establish the identity of whoever you're dealing with. It's through this adequate information that you can satisfy yourself that you're dealing with the right person. Find out what the person does. Are they operating in high risk sectors? We have a national risk assessment that has been disseminated. You might need to take use of that or refer to that, because it highlights the high risk sectors. So in your dealings with the clients, find out what is their nature of occupation to know where to place them or risk profile them. It can give you an indication of the risk factors, the customer risks that you're exposed to, the client risks that you're exposed to as lawyers. And also the monies that are paid into the trust accounts, you need to take note of that. The excess monies in the event that maybe it's a land transaction with that you're holding for your client, a purchase or a sale, and the client pays huge monies into the trust accounts, and all of a sudden they're disinterested about the purchase, and they want you to divert the funds, pay the funds to a third party. So there's so many red flags, which is not a discussion for today, but my communication is you need to put in place these necessary controls, know your client very well, establish the identity of your client, monitor the transactions of your client since you hold accounts for clients, and also make sure that you screen your clients against the sanction list. In addition also to what Cynthia mentioned about the sanction, we have 3 sanction regimes. I can add to the sanction regimes. She has mentioned about the UN sanction regime. We have the OFAC, Office of Foreign Asset Control. These sanctions are administered by the Office of Foreign Assets and Control. These are US sanctions that are supposed to be implemented on US nationals or those who are residents or any entity that has been incorporated in US and the respective branches across the world. So the EU, we have the EU sanction regime as well. And these are economic sanctions that are issued or by the EU, the European Union, and they apply to countries that fall in the European Union. They're mainly restrictive in nature, whereby the EU, European Union countries can withdraw aid, for example, from a third world country in order to constrain you so that you're back in line, you change behavior. Normally in circumstances where there are violations to human rights by a country, so they try to refrain from providing aid. They put economic restrictions on you. So that's all I wanted to add. Since there are no questions, I think at this point we'll close the training. We are very grateful that you have turned up in big numbers. And to add on to this, we shall please note that there is an amendment to the anti-money laundering regulations, and this introduced the administrative sanctions. So there are penalties to the respective legal obligations that you're supposed to comply with as lawyers or as law firms. And you might need to make use of this information so that you know if you don't file a report to FIA, what monetary penalty or fine does it attract, so that you know if you don't conduct a risk assessment, what monetary penalty does it attract, so that you know if you don't register with FIA, what monetary fine does it attract. So the anti-money laundering amendment regulations, these are the ones that introduce the administrative sanctions. And we are planning to organize a training on this so that we make all accountable persons aware of the penalties. It's not proper to penalize people when they don't know. So we have embarked on a sensitization of these administrative sanctions, and we shall organize for one. So we still call on for your support, the coordinators that coordinated this training, Uganda Law Society and Uganda Law Council and ICPAO. So at this juncture, I would take the opportunity to appreciate the ICPAO, the coordinators from ICPAO, Uganda Law Society, and the Law Council. We are very grateful as FIA for the support accorded to us to make this happen. You've all attended in big numbers and we appreciate. I also thank the participants for taking time to attend this training and for being active in this training. Thank you very much. You're free to leave at, yes, you're free to leave at any time you would like to leave. The training is closed. I would stay online in case there's anything that comes up. Thank you.